From studios at the Milwaukee Journal Sentinel, this is Fourth and State. In this edition, an interview with Ed Fallone, a Marquette University law professor who is running for state Supreme Court. I'm David Haynes. I'm the opinions editor at the Milwaukee Journal Sentinel. Welcome to this special edition of Fourth and State. We're joined today by Ed Fallone, who is a Marquette University law professor and also a candidate for the state Supreme Court. Ed, welcome.
Thank you. Great to be here.
Thanks for being with us. You've said that if elected, you would seek to reverse a court rule that says that justices do not have to step aside in cases involving parties who gave them political donations. Explain why you think that would be an important step to take.
Sure. This is really about public perception. If I'm a losing party in a civil case, I need to feel that I was treated fairly and that the judge was impartial and gave me a fair hearing. If I learn that that judge had received campaign contributions, significant campaign contributions, from either the opposing party or opposing counsel, I would feel that I had not perhaps gotten a fair hearing. And it's about the perception so that people involved in the justice system don't leave the system feeling bitter or doubting the impartiality. And that's why I think it's a mistake for Justice Rogenstack and the other justices who approved the change in the rules to allow broader campaign contributions to be made to justices, including when a case is pending in front of that judge. I think we should go back to the prior rule, which allowed an opposing party to seek that judge's recusal on the basis of significant campaign contributions.
And should justices have to say publicly why they're recusing when they choose to?
I support that. I think that justices should explain the reasons why they are or aren't recusing themselves. Again, transparency in the process is going to promote more faith that people are being treated fairly. And I think that that's really the overall goal of the system, is that everyone views, win or lose, they view it as a system where they get a fair hearing and they are treated in an unbiased manner.
The court has been accused of being a little dysfunctional in the last couple of years. You've said that you could help stabilize the court. What qualities do you bring, and what do you see that needs to be done to do that?
I quibble with the use of the word little.
I think a little dysfunctional.
A little dysfunctional. I think the court is very dysfunctional. And it's not just my opinion. It's opinion shared by many observers of the court, both locally and nationally. The court has gotten itself into a system or a situation where, to use the words of Justice Gableman, it's gotten into a cycle of hostility, recrimination, and ill will, tit for tat, grudges being held. And in that situation, where the court can't seem to get itself functioning properly again, I think it's essential to start breaking through that impasse by changing the personalities. And so the first thing that I can do is just not be a part of that cycle of ill will and not come to the court with anyone holding a grudge against me. The second thing is that in my career, I have a long history of working on multi-member bodies. I've been the president of 2 boards of directors of nonprofits. I've served on the board of trustees of Catholic Charities. I've been the president of the academic senate at Marquette University. So I have a long history of serving on multi-member bodies, and I understand, first of all, that it's very important not to personalize policy disagreements, not to question the motives of someone that you disagree with, and secondly, to build consensus and be willing to compromise. To say that it's my way or the highway and to hold out for everything you want is a sure way for gridlock.
But some of that dysfunction has been attributed to pretty vicious campaigns, political campaigns for this court in the last couple cycles. Do you see that happening in this race and all the money that's gone into it? Do you see that happening again?
Well, I think it is connected, and I think you're right to draw that connection. I think the fact that we have judicial elections, and I'm not opposed to electing judges. I think being a candidate has reaffirmed my support for the idea that judicial candidates should get out and meet people and hear their concerns and not be sort of isolated. But because we have judicial elections, there is the opportunity for outside independent groups who have their own agenda to spend a great deal of money and to influence the election. And that does contribute to the feelings of hostility among the court, and I think it contributes to some of the inability of the justices to trust each other and to be able to compromise without fear that, you know, giving in on a particular issue won't be used against them by some outside group in the future. So I think trying to limit these campaign contributions to the best we're able will contribute to getting the court functioning again.
What do you do about third-party ads that come in and blast your opponent? Do you disavow them? Do you do anything about those?
Well, I'm, you know, this is the challenge of being a candidate, is that you try to run your own campaign, you try to have a message about what you stand for, and there's always the possibility that large spending by an independent group drowns out your message and you lose control of your campaign. So I'm absolutely focused on explaining to the public who I am, why I believe the dysfunction of the court is harming the public, and how I believe we can try and get it under control. The outside spending in political races, unfortunately, because of Citizens United, the Supreme Court, U.S. Supreme Court decision, efforts to ban that kind of spending are extremely difficult right now. But we can provide that large campaign contributions from independent groups do once again provide a basis for a recusal motion if that group and its support is relevant to a case. And that will deter some of this spending. If some of these special interest groups know that large contributions, even in independent expenditures, could lead to a recusal motion against the justice that they're intending to benefit, I think that would deter some of this outrageous spending. And that's one reason why I want to reinstitute that prior rule.
I want to go back to the court dysfunction issue for a second. Gotten a lot of attention, much of it centered on Justice Prosser. And of course, the most outrageous incident involved Justice Prosser and Justice Ann Walsh Bradley. Justice Roggensack, to my knowledge, hasn't really been a huge part of that. How does removing her or electing you change that when really, at least to the public, the two who have been most involved in that are Ann Walsh Bradley and David Prosser?
Well, to my mind, Justice Roggensack has consistently diminished the nature of the problem.
How so?
Well, in today's newspaper, your newspaper, there's an article about her proposed letter of apology arising out of the Prosser-Bradley incident, that she felt the entire court should issue a letter of apology which did not identify either justice by name, that suggested the entire court apologized for, I believe the word she used was inappropriate conduct, and that would be a sufficient resolution of the physical altercation. I think that is a far less satisfactory alternative than allowing the regular disciplinary proceedings to go forward. And it is certainly, it suggests a view that the incident is far less serious than many people believe it is. She has also, Justice Roggensack has also said that the court is doing just fine. She has dismissed criticism of the dysfunction as gossip of the lowest sort. And to me, this is simply part of a pattern of her not according sufficient seriousness to the inability of the court to get along. Another example is the question of public discussions of civility and measures that can be taken to improve civility at administrative meetings. Justice Roggensack led the move to make those administrative meetings private, in part because she didn't believe it was productive to have discussions on how to improve civility on the court. So again, I think she has been dismissive of the seriousness of the problem, and I'm not convinced that the problem can be solved if she's reelected.
What would you have done differently?
in regards to
Yeah,
which...
You said that she didn't really do enough. What would you have done?
Well, I think that, the first thing I would have done is that, the normal disciplinary process, I believe, should have gone forward. I don't believe there was any requirement that any of the justices who were present at the time of the physical altercation recuse themselves. So I think that the normal disciplinary process should have gone forward. And I think by recusing herself and then leading Justices Ziegler and Gableman to follow, we now find ourselves in this difficult situation where there is no accountability on the basis of that incident. And the proceedings are in limbo. And alternatives are not really available to the court because the legislature defines the rules by which judges are censored or reprimanded or disciplined. And outside of the disciplinary procedures, there is no alternative. And so I think that's why we find ourselves in this limbo.
I wonder, aside from the things that the court may or may not have done to improve civility, do you have any thoughts on what the court ought to be doing and to what extent the Chief Justice bears some responsibility?
Well, I think all the members of the court bear some responsibility for not being able to get along, for not being able to put this behind them. I mean, how many years now has this been going on? I think it was in 2010 that I first started reading some of the first articles complaining about dysfunction on the court and the impact it was having on their productivity. I think it was in 2010 that the Wisconsin Policy Research Institute put out an article by Mike Nichols with quotes from former Justice Bablich, former Justice Geske, various members of the bar, talking about the dysfunction. So we've had a period of years now where the situation hasn't gotten better. And I think all the justices bear some responsibility for that. I'm not able to parcel out who is most responsible and who isn't. As a concerned observer, a professor who teaches the next generation of lawyers, I feel there has to be change, that we can't continue. And this is the first opportunity for the voters to make a change.
Mm.
Yeah.
So what sorts of things could the court do, though, internally to improve their ability to work with one another? I mean, do they need a counselor to come in?
Well, I think it's...
Get on the couch and...
Are there procedural things they can do aside from just, trying to get along better?
I think openness and a willingness to compromise will go a long way. I'm very concerned at the number of fractured opinions that come out, where the justices each write separately, and even if they agree in the ultimate disposition, they each have a different rationale. And to my mind, that creates a problem. It's a problem because there's no clarity in the law. There aren't predictable legal rules provided for parties and the public to know what rule might apply to their conduct in the future. Instead, you've got a variation, multiple different opinions. And so one thing I would certainly do is display a willingness to compromise and join in the opinions of my colleagues. If I agree with 80% of what a colleague says, I'll join in their opinion and try to build some trust. And through a pattern of displaying willingness to compromise and being flexible, I think over time trust will build.
The justices seen as one of the conservative members of the court. How would you describe yourself? Are you the liberal candidate in this race? What's your style?
I very much reject the idea that there is any big idea that dictates legal results in a case. I don't have a judicial philosophy per se. I think every judicial philosophy that I've studied and examined as a law professor for the last 20 years has its strengths and its weaknesses, is appropriate in some cases, not appropriate in other cases. And I don't paint myself as having a particular philosophy. Mm-hmm. I definitely believe that the legislature gets to make policy choices, and the court's job is to enforce those policy choices so long as the legislature reasonably arrived at its policy choice in a way that conforms with constitutional requirements. The Constitution doesn't allow arbitrary decisions, for example. But I understand the role of the courts is to defer to the policy choices of the legislature, and in fact, you know, in the Act 10 litigation of Zan v. Fitzgerald, one of my criticisms of the court was in not deferring to the policy choices of the legislature on the open meetings law. So it's hard for me to say whether that makes me liberal or conservative or moderate or pragmatist or whatever, because those labels tend to mean different things to different people.
So are the liberal groups supporting you, misreading you?
I have a broad range of support that I'm very proud of.
Okay.
And it includes business leaders, in-house counsel, former chairman of the Securities and Exchange Commission.
Mm-hmm.
So I feel like I have a broad spectrum of support. The only thing I've promised any group is to be open-minded. And I'm not necessarily surprised that there are some people who feel that they are not getting a fair hearing by the current court and that they might support me. At many events, I've been introduced by individuals who have said to the crowd, Professor Fallone won't rule the way we like 100% of the time, but at least he will give us a fair hearing. And to my mind, that is a great introduction and completely consistent with what I tell people.
I want to go back to the idea of big money in these races. That goes back at least 2 or 3 elections now. Do you have any thoughts on what, first of all, do you consider it a problem? And second, if you do you have any thoughts on what might be done to deal with it?
Yes. Absolutely, big money is a problem. The cost of running a statewide election is such that very high-quality people are deterred from running, and it limits the pool of potential candidates. And that's bad enough in a political election, but in a judicial election, I think that's particularly unfortunate. What I would suggest, and again, because the United States Supreme Court Citizens United case makes the banning or limiting of spending in these races difficult, then I think you have to approach it on the funding side. And the Impartial Justice Act, which is still on the books, was, I think, very successful in the Kloppenburg-Prosser race. And I think that it should be refunded, and we should continue to have public funding of judicial elections. Whether or not we want to publicly fund political campaigns may be a separate question, but certainly in a judicial election, because of the specialized nature of the race and the position and the pool of individuals that you want to attract, I think it's important to have public financing.
Forgive me for not knowing this. What have you said about Citizens United in the past? Have you, did you oppose the decision?
I said it was a horribly reasoned decision.
So you're opposed to it?
Well, I oppose it in the sense that it was just, I believe, horribly wrong as a matter of constitutional interpretation. It does 2 things that I disagree with. First of all, it goes much further down the road in equating money with speech, which I think is a particular problem in elections, to say that what you spend is the equivalent of what you say. And secondly, it has a very narrow definition of the word corruption, to essentially say that the only corruption that campaign finance laws can address is bribery, when the word corruption at the founding of our country, and as used at the time the Constitution was adopted, had a much broader meaning and included any sort of effort to get special treatment by the legislature as opposed to get the same treatment everyone else gets. So corruption was understood much more broadly. So when the Supreme Court in the Citizens United case says the only corruption that can be addressed is bribery or spending that approaches bribery, I think they had a very narrow definition of that word that was inappropriate. I could go on for half an hour if you want. I don't think you want that.
Okay, that's all right.
Given the points you've raised about the problems with Citizens United, the problem with attracting a bigger pool because of campaigning, but you still support elections.
Yeah.
Don't you think that if we had an appointed system for the Supreme Court, like some other states, that would be the way to more head-on address a lot of those concerns?
I'm not opposed to an appointed system. I'm not quite ready to give up on elections. I really do understand that if you had an appointed system, you would have perhaps someone who's appointed from a large law firm, or appointed from a government agency, or appointed from a circuit court judgeship, and that might be someone who is not exposed to a wide segment of the state. People around the state have different interests, and it would not be exposed to a wide segment of the population. As a candidate, I've had people pigeonhole me and talk to me about their concern over incarceration rates for minority youth, their concern over the legalization of medicinal marijuana, their concern over jury nullification, a wide segment of issues that are of concern to people. And I don't necessarily take away from that how I should rule in a particular case, but it does inform me about the things that the people of this state care about. And I think that will make me a better judge when I'm on the bench.
What are your experiences?
I have a broad base of legal experience throughout my career. I began as a practicing lawyer representing corporate interests in both civil litigation and criminal investigations. Since I've been at Marquette on the faculty, I've been a full-time academic, a scholar, teacher in areas of constitutional law, corporate law, criminal law, administrative law. I've continued to practice as of counsel, representing businesses and investors in disputes in federal and state courts. And I have practical experience with the concerns that working families have trying to find affordable lawyers. I've been very committed to access to justice issues, both at the state bar, where I was on the board of the Wisconsin Trust Account Foundation and chair of the grants committee, helping to give grants to organizations that provided access to justice to individuals, and as the president of Central Legal, and helping to get that nonprofit started, which provides affordable lawyers in civil and criminal misdemeanor cases, and to this day continues to thrive. And when I was on the board of trustees at Catholic Charities, I helped to bring to Catholic Charities a legal services organization that provides affordable lawyers to immigrants in their effort to stay in this country, people who have a legal claim to be here but were at risk of being deported because they couldn't afford a lawyer. So I have a practical knowledge of the challenges that working families face in trying to navigate the justice system without the help of a lawyer, and ways to address that concern. So I think that my experience is extremely broad across many areas of the law and extremely deep, both theoretical and practical.
But you have no judicial experience. Why isn't that a detriment?
It's not a detriment because many of our Supreme Court justices came to the bench with no prior judicial experience. In fact, the last three Chief Justices, Justice Abramson, Justice Day, and Justice Heffernan, none of them had prior judicial experience prior to ascending to the court. And I would note that Justice Rogensack has no experience as a trial judge. And so her experience is solely appellate, and the way she describes it is that she has experience judging other judges. And if that's how you describe the appellate experience, well, I have 20 years experience as a law professor every day judging other judges.
You mentioned your activity regarding access to justice. Would you have, had you been on the court already, do you think you'd have taken a different vote or taken a stronger view when they were considering rule changes to implement civil Gideon, and instead sort of said, geez, we like this, but it's a legislative, it's a money issue?
Yeah.
I mean, and there were, I know, lots of people in the bar urging them to say, look, that you're in this position to make this happen. They'll find a way if you, the court, can take a stand and make a rule and suggest it. Would you have taken a different position on that?
No, I absolutely understand your question. The civil Gideon rule would have provided for state-funded lawyers for the indigent in civil cases. And while I absolutely am in favor of the principle, the problem there, and as someone who's actually been a leader with organizations attempting to provide affordable legal services, I understand that the real issue here is funding and sustainability. And that was one of the things at Centro Legal that was innovative about that organization, was that by having a sliding scale fee structure and bringing in some fees in addition to grants and donations, it was able to sustain itself. When many people would say, well, you can't charge fees at all, these people can't afford it. And you say, well, if they can afford $100, $200, that helps cover the overhead. So sustainability, to my mind, is the key. And to adopt a civil Gideon rule without having in place a funding structure that is sustainable for the long term, I think would be a mistake. So that would be the key. I'll give you another example. On the board at WISTAF, the Wisconsin Trust Account Foundation, the grants we gave came from interest from lawyer trust accounts, money that was earned off of client funds that were being held by the lawyer. Interest is paid by the bank. It doesn't really belong to anyone, and so the state bar scoops it up and hands it out. The problem was, at one time, interest rates were 11%. Now, then they dropped down to 1.5%, if at all, and the entire funding base for those grants disappeared. And so that's another example where I've seen that if you don't have a sustainable funding model, it's best not to go down that road at all.
Back on the question of political ideology, your former rival, Mr. Magna, boiled this down to the fact that he was a Democrat and Justice Rogan Sachs a Republican, in essence. How would you characterize her views? Is she a partisan?
Well, I'd prefer not to characterize my opponent. I'll let her characterize herself. I think that my response to...
This is an election, though. You can characterize it. You're free to do that.
I'm free to do that. Well, I mean, I'm certainly very comfortable being critical of Justice Rogan Sachs when she's made decisions that I disagree with. But in terms of putting her into a political or ideological box, I'll let her decide what box she fits in. My response to Mr. Magna's approach to the campaign is that the public already views our state Supreme Court in political terms. And I don't believe that that's a positive. I don't think it's a positive when the public predicts how the court is going to rule based on political ideology and comes to view court elections as being about my political party winning or losing. I don't think that's a positive for our state. And so I think interjecting questions about partisan political affiliation is contributing to the problem. I like the fact it's a nonpartisan race, and I hope I'm running a nonpartisan campaign. That's my desire.
Mm-hmm. What are some case decisions that you disagreed with her?
Where are you critical of her?
Well, in specific cases, there's one instance, Forbush, Wisconsin v. Forbush, where I think the entire court fell down on the job. It was a case involving the constitutional right to counsel. And when law enforcement is interrogating a suspect and they learn that suspect is represented by a lawyer, when that interrogation must stop. And really there was a simple issue. Under the Wisconsin Constitution, there was precedent that when law enforcement learns that the party is represented, the interrogation must stop. The U.S. Supreme Court, in interpreting the federal Constitution, subsequently came down with a case that said the interrogation can go forward. And so the only question was, in Wisconsin, would we continue to follow the Wisconsin rule, or would we adopt, as the Wisconsin rule, what the U.S. Supreme Court had adopted? And from my perspective, the task here is to provide clarity and guidance to law enforcement so they can train their personnel. And there's arguments for either rule, but at the end of the day, whichever rule the court picks, as long as there's clarity and guidance, law enforcement can train their personnel how to appropriately conduct interrogations. What we got in Forbush was, I believe it was 5 separate opinions, 3 in favor of the Constitution requiring the interrogation to halt, 2 dissents saying it could go forward, but 5 different rationales. And Justice Rogensack, her separate opinion, which was not joined in by any other justice, was a very long analysis and examination of the historical roots of the Sixth Amendment, which I felt really didn't address the key question: which rule? Which rule and why? And it was a shame to me that the justices could not come together and provide a clear rule on either side. And then the case where I feel she, shall I say, could have done better, is a case called De Bruin. It was a case involving a contract between a church and their minister. And Justice Rogensack, again writing separately, argued that under the First Amendment, the courts could not enforce a contract against a religious institution, which I think is quite a broad extension of First Amendment doctrine. The business of the courts is enforcing contracts. That's one of the main things our courts do, is enforce contracts. And it seems that under the facts of the case, this particular contract was unenforceable as a matter of contract law, and that was a sufficient grounds for resolving the case. And in fact, several of her colleagues wrote separately to say this contract is unenforceable. There was no need, in my opinion, to go and reach out for the constitutional issue. And when she did reach out for the constitutional issue, I believe she went much farther than precedent would support.
There's a case that some of the groups that are supporting your campaign refer to, Peterson versus DNR, a pollution case where a citizen asked for some relief, and she apparently sided with the company. Are you familiar with that case? Are you critical of her in that case?
I have not chosen to criticize her on that case. I'm aware that some independent groups have chosen that case. My campaign has not.
Okay.
You alluded earlier to the dysfunction in the court. I think you mentioned harmed productivity. What's the evidence for that?
The Wisconsin Policy Research Institute in 2010, article by Mike Nichols, interviewed members of the bar and pointed at fewer civil and criminal opinions being issued each year than had been the previous case, fewer petitions for review being filed with the court, an indication that lawyers were advising their clients not to appeal adverse decisions because they weren't very confident as to how the court would handle an appeal, and the increasing fractured nature of opinions, greater incidents where you have multiple separate opinions issued in one case. In terms of the fewer civil and criminal cases being issued each year, it is an undeniable fact that prior to the 2006-2007 term, the court was issuing civil and criminal opinions around the area of between 85 to 100 civil and criminal opinions each year. And then after 2005, 2006, that dropped off, and they've never approached that level. It's been an average of about 65 on average in the years since. There's been some dispute over using the court's official statistics to back up that drop-off. I certainly think that the official statistics of the court demonstrate that. There's some dispute. But even if you don't use the court's statistics, you can simply count the opinions. And you can count and see that in 2004, 2005, I believe it was 98 or 99 combined civil and criminal opinions. 2005, 2006, I believe it was 84. And then subsequent to that, it never gets higher than 74 in any year, and the average is 65. So it's undeniable that they are issuing fewer opinions. In terms of the petitions for review being fewer each year, the statistics of the court demonstrate that as well. Mm-hmm. And so these are things that not only in the 2010 Wisconsin Policy Research Institute article, but as I go around the state and talk to members of the bar, they're reconfirming for me these same points. So at least...
so you don't think it's just that we're in sort of a cycle where there are just fewer opinions coming to the court, or fewer cases coming to the court, I mean?
I don't think so. I don't think so. And certainly in terms of could they hear more cases if they wanted to? Could they grant more petitions for review if they wanted to? I think the answer is clearly yes. I mean, there are significant cases where petitions for review are not granted. And I'm hearing from lawyers as I go around the state saying that, you know, I had a great case, important issues, you know, either I advised my client not to appeal to the court because we couldn't predict with any certainty what the outcome would be, and we thought the risk was too much given the current environment, or I did file a petition for review, but they didn't accept it, and you know the feeling is that because the members of the court weren't sure how it would go, they decided not to take it. So what I'm hearing is consistent with this statistic.
So assuming your impression is correct, what's the impact of that on the justice system in the state?
In other words, are we all better off because they're doing less damage? Is that
I'm just asking.
Well, you know, the state Supreme Court is the ultimate body responsible for the administration of justice in our state, and they have a variety of important functions, and one is the case deciding function. And so they are the final word on what the law is in many instances in Wisconsin. And so I think their productivity is important. And then beyond their case deciding function, of course, they're responsible for the administration of our court system, and they're also responsible for lawyer and judge discipline. Those are the three functions. And I think you can look across the board and say, well, they're not performing at top level in either of those three areas.
Do you know how their productivity compares to other Supreme Courts in other states?
Well, I don't know how to compare that. I mean, I think the baseline of comparing them to the period prior to 2006, 2007, when they were deciding more cases, to the period after, I think is a comparison you can make. I wouldn't know how to compare Wisconsin's level of productivity to another state, say like Montana versus New York. I wouldn't be sure how to do that comparison.
Coming out of the primary election, Justice Roggensack had a pretty major fundraising advantage. I wonder if your campaign has been able to close that gap significantly?
Well, I can tell you that from the beginning, my campaign has had a fundraising plan with targets weekly and daily. And from the beginning, we have met all of our targets. So I am very confident that we will continue to meet that plan. Now, obviously, Justice Roggensack may have greater resources than my campaign, and she certainly has independent groups who have demonstrated they're willing to spend a great deal in support of her candidacy, and I'm not so sure I can match the independent expenditures.
Well, given that advantage and her incumbency, how do you win? What is your strategy to win?
Well, the strategy to win is simply, first of all, to continue to explain and educate the public about the dysfunction on the court and how it is impacting everyone in Wisconsin, and secondly, to get out the vote. This is a spring election, and if we get a normal spring election turnout, then I agree with the premise of the question, which it would be quite difficult for me to prevail. But if we can improve that turnout, get more people to the polls, I think the higher the turnout, the greater the likelihood that I will prevail.
Do you see any, either on your own strategy or people coming to support you, the fact that you're a Latino candidate, bearing anything on the race somewhat here? I mean, that was a big factor in a local race. I know it's just one county, but when Judge Stark was taking on a short-term, but an incumbent, that was a big factor. I mean, a lot of people who watched that race said that was a big factor for her. A lot of groups supported her for that. She reached out to that community. It was a big boost for her in a sense. Do you see any of that happening in your race, and do you think that could be a factor?
Well, I am absolutely receiving the support of Latino leaders throughout Wisconsin, and I've been, as a Mexican myself and active in the Latino community, working in nonprofits there for 20 years. I was hopeful for and gratified to receive a great deal of support from the community. I think in Milwaukee County, I think that can be very helpful, and I'm seeing a great deal of excitement in the community. Around the state, I'm not sure even that many people realize that I would be the first Latino on the court. I think it's a positive. I think that if we do elect our judges, one reason why we do have judicial elections is so that the judiciary is reflective somewhat of the population and is not just some elite segment. So I think it is a positive to my campaign, and I'm hoping it will help.
Go ahead.
Do you have a sense at all of whether the outside groups that are supporting you are being outspent, and by how much compared to the outside groups that are supporting her?
I have no idea what the outside groups are doing, and I probably shouldn't have any idea what they're doing under the law. It's this crazy situation that defies logic, where the candidate runs their campaign, and then you just wait and see what other people are going to do, either to help you or hurt you. And I'm very gratified that there are groups out there who are working independently on my behalf, but I have no knowledge of what their plans are, what their spending is, what any of that.
Is there anything in the ads or literature by the groups that are supporting you that you disagreed with, or taken issue with? If
you could give me some, I would maybe be able to answer. I saw one of the mailings. I saw a piece of literature at a fundraiser for me that someone had, and I tried to get a hand on it because I had not seen it, and I couldn't. It sort of passed its way around the room and was gone. So I have not actually seen any copies of mailings. It seems odd. You probably don't believe me, but that's the truth.
We believe you.
Okay. They don't. I'm not on the mailing list. So I don't do it.
Well, that's an oversight.
Is your campaign going to be on the air with television ads?
Yes, we're going on TV. Yes.
And when could we expect to see them, do you think?
Well, the plan is at a minimum a couple weeks before April 2nd, the election date. We'll see if it can be any earlier than that. We have to be incredibly efficient because we are the challenger here. We don't have deep pockets. I'm very proud of the fact that through my first campaign finance report, the majority of my contributions have been from private individuals, not from PACs, not from groups. And the average size, my understanding, the last update I got, the average size of my contribution to date has been $125. So this is a campaign that has been funded by individuals and not by PACs. So I'm very gratified at the financial response and support, but we have to be incredibly efficient. And so we have to be careful how much we spend, when we spend it, where we spend it.
I wanted to return to the recusal issue for a minute. You've been critical of Justice Rogensack for recusing in the ethics case involving Justice Prosser. She makes the argument that she was a witness. In that, I guess, in that sense, there's a bias there or whatever, and I was involved in the incident, so I shouldn't judge him. What's wrong with that argument?
Well, I think that it's a choice. It's not required. I think that the recusal statute, Wisconsin Statutes Chapter 757, the material witness provision there does provide that in a civil or criminal case, a judge who is a material witness to that case should step down. But a disciplinary proceeding is not civil and it's not criminal. The internal operating procedures of the court make it very plain that case deciding jurisdiction of the court is different from the regulatory or disciplinary jurisdiction. The official statistics of the court break out civil cases, criminal cases, disciplinary cases. And elsewhere in Chapter 757, the same part of the law that she cites to, elsewhere in that same part of the law, you have the procedures for disciplinary proceedings set forth. And there it says, where practical, you should follow the civil procedures in a disciplinary proceeding, where practical. Well, it's not practical to do that if following those procedures means the entire case falls apart. Mm-hmm. And I think it's very clear, both from the statutory language and the way in which the court has always considered disciplinary cases, that there was no real requirement to recuse. There's also been much made of the rule of necessity, which is a separate common law rule that says a judge may stay on a case if there's no other way for the case to go forward. And I think that provides an independent reason. So the result is we have in place procedures set forth by the legislature, an independent judicial commission that investigates, files charges, then the matter is usually given to a 3-judge Court of Appeals panel. Eventually the state Supreme Court decides it. Seems to me an eminently reasonable process that protects the rights of the judge facing the allegations. By choosing to recuse herself, Justice Rogensack led the charge. There was now no longer sufficient quorum, and now we're left in this limbo where we had procedures that seemed fine to me, safeguarding the rights of all involved, and now we're in a situation where we don't know what to do. She has suggested the court has some inherent power to proceed. I don't know to what she's referring. I know in the state constitution, Article 7, it says that the only body that can make rules that would sanction, reprimand, discipline a sitting judge is the legislature. So I'm not sure how the court could make an alternative proceeding without violating the state constitution. So rather than get in this situation, I believe it would have been far preferable for Justice Rogensack to simply stay on the case, let it proceed.
Any other questions? I wonder if you could just close, take a couple of minutes and make the case for Ed Fallone.
Well, the case for Ed Fallone is simple. I've demonstrated over a 25-year legal career that I am an independent thinker, well qualified across a broad area of the law. My business law expertise is not currently represented on the court. I've been a member of the board of directors of the business law section of the state bar. I helped to write the Wisconsin Uniform Securities Act. I'm supported by a wide segment of business lawyers, leading business lawyers across the state. My constitutional law expertise, I'm widely sought out by members of the staff of this newspaper and other media for comment on constitutional issues, both federal and state. My criminal law background, both as a practitioner involved in white-collar crime matters and as a scholar writing on corporate crime issues. My practical experience leading organizations that have tried to increase access to affordable lawyers for the middle class. I think this is an extremely broad and deep background in the law that makes me eminently qualified to serve on our state's highest court. And given the dysfunction on the court, I don't believe re-electing Justice Rogensack will solve the problem. It will simply persist, and therefore I think it's time to make a change.
Ed Fallone, thanks for being with us.
Thank you.
It's been a pleasure.
Appreciate it.
Thank you so much.